Start para. These petitions filed under Article 226 of the Constitution of India seek a writ of mandamus against respondent numbers 1 and 2 for issuing an occupation certificate (OC) for the petitioner's property. Additionally, the petitioners request a waiver of additional municipal taxes and consideration of their application dated 27th May 1999. The learned counsel agree that common issues of law and facts arise, and therefore both these petitions could be disposed of by a common judgment and order. Para. The respondent number 3, Raj Realtors Construction Company Private Limited (developer) purchased the property from Mumtaz and others under a deed of conveyance dated 15th December 1986 with an intention to develop. The property comprised 3 chawls with 9 shops and 9 residential tenements built in 1946, with the petitioners as tenant of the shops and other tenant occupying the residential tenements. After purchasing the property, the developer filed a suit in the Small Causes Court for a decree of possession, asserting their intention to develop the property. The suits were settled through consent terms, whereby the petitioners agreed to cooperate with the developer for the property development and handed over possession as per the consent terms. Those are annexed as Exhibit A on page 25 of the petition. Each petitioner signed similar consent terms. Whereas the front wing was constructed to accommodate the petitioners in possession of the shops, the rear wing, consisting of stills and 6 storage, was meant for residential accommodation for the tenant, with the remaining flats to be sold by the developer. Upon completion of the front wing consisting of shops, the petitioner were asked to take, and they took possession of the shops as contemplated under the consent terms and were assured of an occupation certificate once the rear wing was completed. Apparently, the developer failed to secure the OC for the shops. Consequently, respondent number 1 (BMC) did not provide water and sewerage facilities to the petitioner, but nevertheless charged them 150% of the normal property tax. Upon inquiry with the BMC, the petitioner were informed that the OC was withheld because respondent number 2 (MHADA) had not granted the final no objection certificate (NOC). The BMC communicated with MHADA for the NOC for the commercial wing occupied by the petitioner on 4th March 1997 and sought an urgent appraisal while acknowledging that MHADA misplaced the original file. Communications inter se between the petitioners, BMC and MHADA commenced and have followed since 27th February 1999. The developer was granted a floor space index (FSI) of 2 for the project, for which he was obliged to give MHADA an area of 1986 square feet, which he defaulted on. The developer's default resulted in the petitioners facing a 150% property tax penalty. On 24 January 1996, the petitioner received a final notice to pay rupees 5,08,069.60 to the BMC. Mr. Thorat, representing the petitioner, submitted that the petitioner were charged additional municipal taxes. The BMC demanded rupees 10,52,375.60, of which the petitioner paid rupees 6,88,500. The balance amount pertained to additional municipal taxes. The petitioner were charged rupees 1,45,886 for the period before they were put in possession by the developer. Mr. Thorat argued that rupees 5,66,375 shown as arrears were additional municipal taxes for non-issuance of the OC, which they were opposed to paying as per petitioners were not obliged to obtain the OC. The obligation was of the developer. Stop.